I have my colleague Per Oscarson with me on today's webinar that is about the brand new changes that the Washington legislature has put in place for our LLC Act. There are other changes in the Corporate Act as well as the Partnership Act, but today we're only going to be talking about the changes that the legislature made to the LLC Act. And just give maybe just a minute of background here. So our Washington's LLC Act was first enacted in '95 and really didn't have much in the way of changes, like some clarifying changes and things like that over the years until 2016, when a full-scale revision of our LLC Act happened. And I got a front row seat for that. It took us about 8 years, I think, to get the LLC Act revised and replaced. I was on the committee, the drafting committee for that, which was just an absolutely fascinating process. And since 2016, haven't been that many changes really at all, more procedural things, but the 2022 legislature enacted some fairly significant changes that I think really require us as practitioners to take a step back. And in 2016, we're scratching our head, for example, thinking about things like oral LLC agreements and the challenges that and they certainly do create challenges for us. But now here we are, and we have some changes for things like withdrawal, which is now it was prohibited before without the unanimous consent of the members, which is now going to, the rule is flipped. You can withdraw voluntarily, or a member can withdraw voluntarily at any time, again, unless your LLC agreement says something different than that. And then there's some automatic admission as an interest holder rules that are kind of interesting that Per and I will get into in a minute. And I don't know, Per, maybe less interesting, dare I say, foreign professional limited liability companies, and actually defining what that is. And then in addition to that, easing up or making conversion more difficult because it's going to require the unanimous consent of the members. We'll talk about all of those things. I promise not to talk the whole time, but it is an exciting topic to discuss. Per, you want to give maybe an update, a little bit of background, or do you think we're ready to move forward?
I think we're ready to go. I'd agree. There's probably not an awful lot with the foreign professional limited liability companies because they're going to be limited to attorneys. And my guess is that you're probably looking at larger law firms that might have that involved, whereas smaller firms probably don't.
Yes.
But I guess there's always the potential for an exception there.
Well, yeah, make sure, Per, can you see my screen? Do I have the PowerPoint up? Did I do it right?
I can see it, yes.
All right, very good. So Per and I work very closely together, and here we are. We're going to have a conversation about these new changes. And so these are the four that we're going to discuss. Admission of new members, voluntary withdrawal, foreign professional limited liability companies, and approval for plans of conversion. And so we'll begin with the admission of new members. And to me, this is one of the most significant changes this go round. So as the slide says, there's an automatic admission when a transferee, and we'll talk about what that means in a second. In fact, Per, I'm going to tee you up here in just a second. I'd love for you to maybe talk a little bit about the difference between a transferee and a transferor and why we use those words. But in 25-15-116, we've added a new section to Part 2, where 116 is the statute that talks about how do you admit a member. When does that happen? Happen at the formation of the company. It can happen after the formation of the company. And so 2D talks about, and I'll just read this, in the case of a transferee acquiring all of a transferor's limited liability company interest, and I'm holding up air quotes as I'm talking about limited liability company interest, from a transferor that is the only member of a limited liability company upon effectiveness of that transfer. So Per, maybe you could kind of unpack that for us a little bit. What does that mean in maybe more plain English?
Okay. Well, the transferor is the person, excuse me, is the person who is giving, selling, otherwise conveying to someone else their interest in the LLC. The transferee, of course, would be the one receiving that interest in whatever form they receive it. And limited liability company interest also has a definition under the existing statute, normally meaning that they have the right to receive distributions, although that's not necessarily going to be the case for all members, particularly given one of the changes to the statute. But one of the problems that we run into with LLC memberships is when you do have that single member, that the single member that owns all of the interest in the LLC, and if they pass away, now in order to keep the LLC going, there has to be an agreement to do that within 90 days after that death, or then the LLC goes away. But unfortunately, that's one of those things that kind of, I think, pretty often slips through the cracks. And I think that this statute helps with it because hopefully the deceased member's will provides for who's supposed to receive that interest.
Right.
And if it's going to be automatic upon the effectiveness of the transfer, we don't have to worry about, well, did they actually take an action after the member died that allows the new person to come in as a member and continue the effectiveness and the existence of the LLC.
Yeah, you raised the death situation, and let's just go back for a second on that. So a lot of people will have, for example, a limited liability company. They will form one where they will be the only member, and they will do that, say, for the purpose of holding a piece of real estate. So let's say it's an apartment complex. That is the sole asset of the LLC with one member, and when that member dies, the existing LLC Act says that death of the member is an event of dissociation. Okay, meaning that they're not a member anymore.
Right.
And so I think what I heard you say is that when the decedent transfers that interest by, whether it's by their will or by the laws of intestate succession, so the decedent in my example would be the transferor, and all of the transferor's interest, so the decedent's interest, would go to their heir, for example, which could be more than one person.
Right.
And so when that happens, without this change in the law, whoever was the transferee who received that LLC interest, they were not admitted as a member because all they received was an economic interest upon that transfer. And that's just the way the LLCs work.
Right.
That person would not be admitted as a member because it takes the default rule is that it takes the unanimous consent of the members. Well, there's no member to consent to it. and the act goes on to provide that, and maybe you could talk about the consequence of this, that if you don't vote to admit a member within 90 days from the date of death, and using our death example, then the LLC dissolves. What would be the effect of dissolution of the LLC in the example that I just gave, where the LLC owns the apartment complex and its sole member died?
Well, number one, the LLC cannot continue to do any work of what its regular business would be, other than what's necessary to wind up the affairs. And winding up the affairs means paying the creditors and then distributing property. And so now you're going to have to end up with, hopefully there aren't too many creditors involved with the apartment building, although maybe there's a mortgage sitting there, but hopefully there aren't too many what I would think of as the monthly expense type things. And if they are, they're hopefully small. But then you've got to distribute the ownership interest in that apartment building. And if it's heirs, who knows how many new owners you just got of what used to be owned by a single LLC and now is owned by, I don't know, 15, 20 heirs who most likely will not agree on everything.
Right. Well, that's interesting.
So that's kind of the big problem with it.
Could it also require, instead of distributing out the real estate in this example, could it trigger a required sale of the property in the alternative?
I think it could. Yeah, I think that's definitely a possibility. And that's certainly not necessarily something that all of the new owners, if you will, and I realize that's a kind of a bad use of the term, but those who would have a right to it, they may not all be interested in selling. And then it's a question now of, well, how do we deal with the people that don't want to sell, or the ones that do, and that can cause a lot of problems.
Absolutely, and to me, this is a really interesting phenomenon, because most of the time we think about when we enter into a contract, I'm going to sign that contract, right? I mean, we as lawyers, this is what we do. And so if let's stick with with our example of the LLC that has an apartment complex, single member dies, and let's say that this single member was prepared and had an actual LLC agreement. Okay. And so now the interesting effect of this particular change, by admitting all of the heirs, and you're right, Perry, there could be a lot, could be nonprofit companies, could be cousins, people who know each other, some who don't. All of a sudden now they're admitted as members, and they are now parties to the LLC agreement that they probably have never even seen.
Right.
And so
some may not even know what that even means, that there is such an agreement, because they don't
That's
even
right.
know what a limited liability company is.
That's exactly right. And so this language in 216 D, providing acquiring all of the transferor's limited liability company interest from a transferor that is the only member, you could now go from a single member LLC, and because this could also change even the tax consequences associated with this, because you've gone from a single member LLC that may be disregarded, right? Right. For tax purposes, may not exist in the IRS's eyes. And now all of a sudden you're going to have a de facto partnership with people, again, who may or may not know one another. And all of a sudden they're going to be getting, distributions. They're going to get a K-1. Somebody's going to have to take control of this. And all of this might be a surprise, much like there could be a surprise, if in the previous version of the act, where the LLC might dissolve, not might, but the LLC would dissolve if a new member didn't come in 90 days after death. That's certainly a surprise to people. But I think there is certainly room here equally for people to be surprised by, oh my gosh, all of a sudden I'm a member, all of a sudden I'm a partner, all of a sudden I'm a party to an LLC agreement that I didn't sign and I don't know what it says. Right. Interesting times. Interesting.
And I think it's interesting too, given that limited liability companies are kind of thought of similar to partnerships, in that you really are voluntarily getting together with these other members to do this.
Yes.
And now, in our example, now you've been thrown in with who knows how many people, many of whom you may not know, and all of a sudden you're in quote unquote a partnership, at least for tax purposes, with these folks.
That's exactly right.
Yeah.
So here we are. We've been talking about admission of new members in a single member situation. And by the way, I think there are other iterations of this. For example, what if the situation is where the member doesn't die, but what if they go bankrupt? I think there are some interesting, is the bankruptcy trustee now all of a sudden, admitted as a member?
Right.
Well, we're not going to take our time to get into that. The point simply being that I think there can be lots of different consequences here, not just in the death situation, but in other situations as well. So now let's turn our attention from admission of new members to members getting out, the opposite, right?
Right.
And so with any luck, you can see on my screen the voluntary withdrawal is now permitted. So again, just a little bit of background. Right now, and this doesn't go into effect until June 9th. But so right now, the default rule is that if you are a member of an LLC, that you cannot voluntarily withdraw without the unanimous consent of all of the members. And so, Per, you talked a moment ago about, hey, usually with a partnership or usually with an LLC, you want to be able to pick your partners. I refer to this as the pick your partner principle. So once you're in, the way the act works now is you're in and you can't get out. And that's about to change. And so I have on the screen, first of all, the definition of withdrawal. Withdraw means with respect to a member of a limited liability company or a holder of a transferable interest. So interestingly, you don't need to be a member. Okay, so it could be if we're talking about our previous example, and if we an heir comes in to that apartment complex LLC, well, maybe they would want to withdraw. We could talk about the pros and cons of that at a different time, but it means with respect to a member of an LLC or a holder of a transferable interest in that LLC, that the member or holder of the transferable interest provides written notice to the limited liability company. So this is important, okay? That there's written notice in order for there to be a withdrawal. So if you have an LLC that has an oral LLC agreement, voluntary withdrawal still is going to require a document, something that's written. Notice it doesn't say that it's signed, but I've seen situations where you have a multi-member LLC and one of the members, leaves the state, and they have been providing, services to the company, and all of a sudden they leave, move, go to Idaho, whatever, and come back a couple of years later and say, well, I'm still a member. And that would still be the case here, right? Because withdrawal didn't happen because they didn't give written notice. They just picked up and left, and now they've come back. So this will not change that. So to be clear, withdrawal has to be in writing, okay? And there's no magic words that the statute requires, but it comes pretty close, because the written notice to the limited liability company must state that member's intent to surrender all of its transferable interest and rights as a member to the company. So if I write you a note and I say, all right, Per, I'm transferring my interest to you, I'm out of here, that is not a withdrawal by me, because I've given my interest to you rather than surrendering it to the company. Okay, so there is, again, the statute doesn't say these are the words you have to use, but it comes pretty darn close. And it's this idea of surrendering everything you have, and then that it's going to be effective when the company receives the written notice of withdrawal, or if there's a different date set forth in the notice. So again, when you have an LLC that might be operating a bit informally, I mean, this can be a challenge. What does that mean? The notice goes to the principal office? Does it go to the registered agent? Does it go to the other members? How does the company receive the notice? Per, you want to take up maybe a few of the issues that you see here with this definition?
Well, I like the idea of the written notice, certainly, whether you've got a written LLC agreement or an oral agreement. And it would be awfully nice if they had if they had been a little bit more clear about exactly what does it mean to deliver that to the limited liability company. It seems to me, given your example, you could have a couple of different options, as you say, the registered agent. It could be to the principal office. If there's a manager, if you've just given it to the manager, I mean, they represent the limited liability company. It seems to me that ought to take care of it. But it just seems to me that there's the possibility, because there's any one of these, and there are probably some others that I haven't thought of, that might be, quote unquote, delivery to the limited liability company. And there may become a lot of arguments as to, well, did that really constitute delivery to the limited liability company? Or, as you started this discussion, if you're just delivering it to me and I happen to be a member, but I don't have any other authority, assuming
Right.
we've got a manager managed, then yeah, delivering to me, I don't think is going to be effective. I mean, it's interesting. I'm glad to know it, but that's about as far as it goes.
Right. Well, and so let's think a little bit here about the practical import of now, as a default rule, a member's ability to voluntarily withdraw. Where before, Per, if you and I, were members of the LLC, we didn't have an LLC agreement, or a written one anyway. You and I were stuck together, right?
Right.
And now we're not. And so, from a policy perspective, it's a major change that we've undertaken here. And I think, one of the things that I think we as a committee were really thinking about as we made this change was, what would people expect? In other words, Per, when you and I joined forces as members of our LLC, did we really expect that we were joined together forever? Not a marriage, right?
Right.
And so I think the idea here is, no. If we decided to voluntarily, join and become members of an LLC, that we could similarly, voluntarily separate. And so I don't know if we got it right in terms of what people's expectations are, but this is interesting as well when you think about things like fiduciary duties, and if we have again the Per and David LLC. And I learn a lot because I'm working with you every day, Per. I can't go out and, as long as I'm a member, I can't go out and compete with the company because I have a fiduciary duty that prohibits me from doing that by statute. Okay. Well, now, if all of a sudden I think, oh man, Per's taught me so much, I can go do my own thing. I can voluntarily withdraw. I can give the company the written notice, and my fiduciary duty, my duty not to compete with the company, ends at that moment. And so certainly, I think there can be some traps here. Another reason not to have an oral LLC agreement, or just defer to whatever the default rules are. So I'm wondering, what you think about this, a member's now ability to voluntarily withdraw, and give us your spin, Per. I mean, is this a good thing? Is it a bad thing, or is it neither?
I'm kind of feeling like it's a good and a bad thing. Number one, I've always thought it was kind of strange that you get to pick your partners, but you don't get to divorce your partners using the marital dissolution.
That's
kind
true.
of idea.
Yeah, that's true.
And that seems kind of strange that you are really forced. If you're having to rely on the existing default rule, you're forced to stay with the partner and for whatever reason you just can't do it,
Yeah.
or don't want to do it. So I can see on that hand that being able to withdraw makes sense. But on the other hand, using the example you just gave of our LLC, you say you've learned a lot from me, but now you want to go out. And so here I am, I've got whatever knowledge that allows me to continue the operation of the LLC, although now I may be in competition with your new entity or
That's
your
right.
new business, even if it's not in an entity. But what if the shoe's on the other foot? Maybe I decide that I want to leave,
Yeah.
and if the contributions, whether they be financial, skill sets, or anything, are more heavily in my favor, it's great for me, but it puts you in a really bad position if you don't have the financial ability to continue operating the LLC that I just left.
That's right.
And so it seems to me that we're probably going to see good and bad results from this. The flexibility is great, but on the other hand, I think it's still going to be the issue of if there's an imbalance in the contributions to the LLC, whatever they might be, of the withdrawing member, I could see where that could still have a pretty negative effect on the LLC. I can also see it too, though, if it's a member that has maybe a financial interest, but it's a small financial interest, and maybe they don't participate a lot in the management of it, and maybe they don't provide a knowledge base or a skill set that really is absolutely necessary for the LLC to continue to exist. If they were to leave, it may not have much effect on the LLC at all.
Right.
So I could see quite a wide variety of possible results.
Well, yeah, and I do too. And what I really see this is as really it makes our jobs as drafters, I think, that much more important for the very reasons that you've just identified. And so one of the great things about LLCs, we only have a few more minutes here, but one of the great things about LLCs, and it's written right into the act, which is the legislature says, look, we are intending to give the maximum credence to the principle of freedom of contract. And so and that's, it's a double-edged sword. And so it really becomes you can do in large measure, subject to certain limitations, you can do anything you want with your LLC.
Right.
But you got to decide what you want. And not deciding, has its own consequences. And so here, I think it's really critical that we as practitioners are thoughtful about this issue, which frankly, we haven't probably been that thoughtful about before, because I think most of us want to keep everyone in. That's the idea here. But as a default rule, that changes. And so certainly our drafting on that particular point needs to be sharpened, I think, a bit.
Yeah. Well, I think the thinking going into it's going to have to be pretty more involved.
Yes.
Because I'm sure there are situations that people just don't consider when they're going into this, creating the LLC and saying, okay, this is what we're going to do.
Right.
There's probably a lot of situations where it just doesn't even cross their mind that this may come up and how we're going to deal with it.
Well, we've got just a couple minutes left, and so I'll just bring this up on the screen very briefly. We've clarified that a plan of conversion now requires unanimous consent as opposed to majority for a plan of conversion. And then we also have clarified that a foreign LLC can actually be a member of, a foreign professional LLC can be a member of a Washington professional LLC. So certainly we do a bunch of work for professional LLCs here. And so I think it kind of plugs a hole in our statute a bit, although not a major hole. Well, we're out of time. Wanted to simply remind everybody, I'm Dave Tingstead, Per Oscarson, my Scandinavian cohort here, and we love what we do. Certainly would be interested in helping you, because I'll tell you, LLCs are a wonderful tool, but really must be approached with care. Per, I'm going to give you, this is rare, I'm going to give you the last word.
Well, to quote someone who is pretty famous around here, let's be careful out there with all of this.
I agree. I agree. Until next time, we're signing off. Thanks, Per. Well said.
Thank you.